Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. The Honorable Supreme Court of India refused to grant anticipatory bail to an IPS officer who used a cheat or a con man in the name of the then Chief Justice of Patna High Court to influence a DGP of the same state. This sentence can be cut into 3 pieces and then only you will be able to understand the essence of it. Right, now, Honorable Justice Aniruddha Bose, Justice Ahsanuddin Amanullah and Justice Augustine George Marshi in the case of Aditya Kumar versus State of Bihar in SLP number 4496 by 2023 dated 22nd November 2023 refused to give anticipatory bail under section 438 CRPC. Of course, here it comes under article 136 of the Constitution of India to an IPS officer. Right, now you read the sentence. Supreme Court refuses to give bail to an IPS officer. What the IPS officer done? He used a con man or he used a cheat and a DP was created for the cheat as though he was the Chief Justice of Patna High Court. So the con man used to speak as though he is the Chief Justice of Patna High Court. Then what did he do? The con man asked the Chief Justice to just recommend the case of the particular officer to the DGP to drop proceedings against him in a corruption case. Actually, ED found out all these things and they have laid a trap on him. This matter has been pending for the past, I think, 1 year or so. Even he has approached the Supreme Court in the month of May. They have given some orders of protection or something, asked him to cooperate with the investigation. Now, when the regular topic has come, Supreme Court, basing on the seriousness of the gravity of the offence, refused to grant him anticipatory bail. Right? Please remember, this previously Patna High Court also in the third month, I believe, they have refused to grant him anticipatory bail because the seriousness of the case. So the sections of law, please remember, a case of course, 353 is obstructing the public servant in the discharge of official duties. Then 387, extortion. 419, 420, cheating. 467, forgery for the purpose of cheating. 468 and 120B, criminal conspiracy. Very, very important sections of the IPC. Not only that, IT Act also is there. So, sections 66C and 66D of the IT Act. So, morphing he has prepared a duplicate DP of the Chief Justice. All these things were done. Right? With this, what he has done. Now, if you go to the background of the case, you can know that while this man was working as Superintendent of Police Gaya district, he had differences with another IPS officer who was working as IG at that particular time. And the allegations are that he is having links with the so-called anti-social elements who have become rich or who have earned so much of money in his name. ED has to interfere, particularly since it relates to the so-called vigilance case or excise and prohibition cases. Now charges were framed against him. Therefore, he wants to come out of the same. As such, he has asked his friend, who is a con man, he asked his friend to purchase SIMs. 2 SIMs were purchased and this man, the con man, created a DP as though he is the Chief Justice of Patna High Court and they used the number to influence the DGP. DGP got it out. What is this? Chief Justice of India normally speaks to the DGP, but he will not recommend any case. You all know according to the doctrine of separation of powers or independence of the judiciary as per Article 51 of the Constitution of India. So definitely they are 50. They are separate. They don't try to influence the court. But this happened. Therefore, he asked the CID DSP to probe into the matter. Ultimately, it was known that some other person acted on behalf of this man. The con man was arrested. Then he has given a clean burst of confession that because of his friendship with the so-called IPS officer, he has resorted to this. He was arrested. Now the case is against this man also. He has approached the Patna High Court, which refused the bail. Now he has come to the Supreme Court. Supreme Court also said no. Why? This is the court will certainly not shut his eyes on the materials unearthed, because it relates to maintaining the purity in the judicial proceedings and, of course, upholding the public faith in the judicial system. Is it not? So, therefore, the Supreme Court, 3 judges bench, we are of the firm view that no bail is given, and further directions they have asked the Patna High Court so far as to what departmental action has been taken against him. So the apex court denied him bail basing on the gravity of the offense. Please remember. Now, the reliance was placed on 2 important cases. Sumita Pradeep versus Arun Kumar CK 2022. Right, and Dharmaraj versus State of Haryana 2023. So normally you are under the impression that we will be requesting the court, Your Honor, since no custodial interrogation is required, they may be given bail. Yesterday in the case of law students, in that video also we have stated Supreme Court is of opinion that no custodial interrogation is necessary. In such cases, better to give bail. But in Dharmaraj's case, it is clearly held that the Supreme Court or any court has got discretionary power even to give anticipatory bail. Anticipatory bail is not a right. Please remember, the court has got discretion. So basing on the reliance on the 2 cases, Honorable Supreme Court of India denied to give him bail. If you know this much, it is sufficient. Thank you very much.